Sir, we have a Q&A session. We have few questions in the chat box. Now I request my colleague, Dr. Irfan Abbas, to take care of the Q&A session and moderate it. It will take for about 5 to 10 minutes.
Very good evening, sir.
Good evening.
Sir, there is a question from one Mr. Satyendra. Sir, the question is relating to how can we protect a national industry's design from foreign industries' design in terms of competition in manufacturing techniques and businesses?
You have so many possibilities here. One lacuna that we have in India is that we do not give protection for the unregistered design. However, registration of the design at the earliest point of time, which is perhaps the simplest process in India, even before any such registration is done by the foreign companies. Right? That is one way that you're going to get ensure protection. But before you file these applications, I'm sure you'll have to do an international search for that. So as you find novelty and the patent law being absolute novelty, where publication anywhere is going to damage your novelty or originality. And similarly, here also there's a problem. And therefore, you'll have to do an extensive international search for existing designs across the globe and then go in for registration. Ensure that your registration, your design is distinct from the other design. I think that is the one. Otherwise, first mover is always a beneficiary. And therefore, you'll have to anticipate the entry of those bodies into the country, and then you'll have to go ahead and get it protected, right, as early as possible. I think that's a business decision. I don't know whether there's any legal question involved in that, unless he has some specific legal issue.
Thank you, sir. Sir, we have a small question from our side, sir. Sir, being a senior academician and luminary in the field of IPR, do you see any changes that are required in the design law in India? And how do you see the future of designs as an intellectual property in comparison with patents and copyrights?
We can list the lacunae in our Designs Act, starting from the definition part itself. See, the UK has gone ahead and then it has changed its legislative frame. It says that any visual appearance is sufficient, and we are still clinging on to the aesthetic appeal, which is subjective and which cannot be decided properly. Starting from that we have not expanded the scope of the definition of designs, number one. This is one first part. Second part is that the limitations that we have put on the design protection are also not adequate. So we have not expressly provided anywhere that functional features are not registrable, but the practice has continued to exclude the functional features. And like that, I think even the remedies, if you go to the remedies, civil remedies are there. You pay 25,000 rupees and continue violation, and the maximum that you are required to pay is only 50,000 rupees. Perhaps an industrialist would not mind paying 50,000 rupees and continue with the infringement. It's like pay a peanut for that. And should there be some criminal remedies attached to it? We don't have criminal remedies at all, right, in this designs law. Neither designs law has criminal remedies nor patent law has any criminal remedies. This is first part of the answer to the first part of your question. Second part of the question is, yes, designs law has a lot of potential, especially in the context of the consumer goods and the articles that are being unleashed across the globe. And each one of them, especially the garment industry, fashion industry, right, and many other, all these are unleashing the articles on which they have this design protection sought. And therefore, you should not be leaving it to the lazy copiers to copy, rather facilitate them to come out with creative designs so that the creativity would last long. And for that, from that perspective, I think design law is going to be still important. I would not say that this is more important than patent system. I would not say that this is more important than the copyright or the geographical indications. Let me not compare that. Each one has its own field. Each one has its own market. Each one has its own type of protection. Because for starters, you remember for the starters, we keep advising them, go in for a comprehensive IP protection. Have a patent, have a copyright, have trademark, have designs also, although you cannot have geographic indications. Right? So that's the kind of protection that we always think of, especially in the light of development that are happening now. We need to amend our designs law considerably.
Thank you so much, sir. We have one question from Dr. Nandini. Sir, when we consider that IPR are private rights, why should we extend criminal liability also for patent and designs?
That's a very large question, Nandini. I think that needs a very serious debate on the principles of criminal law and when and what are to be criminalized, etc. My response here was that is also one of the lacunae in the existing legislative framework for an effective enforcement. This 25,000 rupees and 50,000 rupees has no coercive effect whatsoever on the infringer. In that context, I said it must be much more stringent. For that matter, copyright is also a private right. Trademark not only protects the individual but also protects the consumer. Right? Something similar to the design also. Isn't it? Patent is in the interest of an individual, but is not patent in the interest of the community as a whole. And if those are infringed or violated, should there be more stringent remedies? From that perspective, I was using the word stringent, and there is no criminal remedy available. I did not strongly mean that it should criminalize the infringing activities under designs.
One more question from Dr. Nandini, sir.
Okay.
Sir, should we take protection from copyright for designs as well as under Designs Act for designs? That is both under Copyright and Designs Act, and how different are they when it comes to their protection and remedies?
That is where we have a lot of problems. And that was one of the issues that we have been pondering over, starting from the case that I refer to, microfibers case, till Holland case, and the present, a month back decided case of Havel case. All of them have debated on the overlap between copyright law and the design law. And there are series of articles written on that as to which one is subordinate, which one is core. Say, for example, trademark. Trademark is excluded. And the cases that have been decided on composite suits have said that passing off is not the core trademark features. It is subsidiary trademark features, and therefore passing off can be a composite suit along with design infringement. Nobody knows what is that core and the fringe one. How are you going to decide that? Right. Similarly, section 15(2) is mired in controversy. Why it's mired in controversy? In my opinion, right? You have used the term copyright in design, number one. You have also said that 50 articles are made. What is the rationale for these 50 articles? Nowhere, right? I asked one of the researchers to do research on that and find out where it emerged from. They could not trace it. Anyone from this audience, if they trace it and then send it to me, I'll be happy. Why this illogical thing? And therefore, should we go ahead and then say, well, if it is not registered under Designs Act, we should be entitled for an unregistered design protection, the way you have CDPA. Can you make that change? I'm sure that one change is going to ensure unregistered design protection in India as well. One more issue, I think I should point out, Ms. Nandini here. The rule of reciprocity has been applied by UK as far as unregistered design part is concerned. India does not provide for unregistered design protection. So an Indian citizen will not be entitled for unregistered design protection in UK, and only those citizens of those countries which have provided for unregistered design protection will be entitled for unregistered design protection in UK. As a consequence, Indian designers, Indian manufacturers would suffer. I think that needs to be addressed immediately, rather than asking which one is better protection. Thank you, Nandini.
Thanks for clarifying all the three doubts. And I think no one has any other clarifications to seek. I would like to share with you, sir, recently there was a consultation with the DPIIT, in fact, on reforms in the design law. And I don't know why I was called, but I was one of the participants. And there were many law firms. And there was a proposal to increase the term of the design, that is 10+5 to 10+10 or 10+15, something like that. This is one. And second one is there was a discussion on this 50 units limit under Section 15 of the Copyright Act. So what exactly is your opinion on these two issues? Whether there is a need to extend the term of design protection if registered. Second one is, should we retain the 50 limit as far as the units which are produced without registration, and in order to see that the copyright is extended even beyond that, copyright in design.
Thank you. Those are very, very interesting points that you raised. UK has a 25 years protection for designs. Every 5 years it gets renewed. 5 plus 5 plus 5 plus 5 plus 5. Like that, 25 years protection is granted. Whereas for unregistered design, UK has 10 plus 5 years only. 10 plus 5 years, 15 years. Even of this 15 years, the last 5 years is a free-for-all situation. When I say free-for-all situation, anyone can ask for a license of right. And the design holder has no option except to negotiate the terms. If it does not negotiate the terms, it will go to the Patent and Designs Registry. They are going to decide on that. So which means he does not have a right. Only for first 10 years he enjoys. Last 5 years he doesn't enjoy. But as in the Registered Designs Act, it is extended up to 25 years. There is a logic in extending this particular design protection to 25 years. I'm in favor of that. The rationale is that a product in the market, in respect of which the manufacturer would have gained some popularity, right, should continue without being adversely copied by others. And therefore, a longer term of protection would match with the protection under the other regimes as well. For example, copyright regime, you say is 60 years, and this is 15 years. So that mismatch is there. Coming to Section 15.2, I have already shared my thoughts on that. That Section 15.2 should be completely overhauled, including that 50 limit. I'm not saying that it should be increased to 100 or 200 or 300. I'm not saying that. That requires a thorough revision. 15.2 either should go, or 15.2 should completely get recast, so as to ensure both copyright protection for the artistic work and the applied art protection for the design protection for the applied art. How to distinguish that again is a great problem. And therefore, a total recast of Section 15 is required at present, in my opinion. How it should be recast, perhaps we should all sit and debate.
Thank you, sir. I think now probably certainly the reform is needed, and very soon maybe the bill will be introduced. That's what I was told. And these inputs will be certainly taken into consideration by the ministry. As usual, your opinion matters a lot. Thank you so much. You made it, and it makes a lot of difference, sir. It added more credibility to our humble endeavor for spreading more IPR awareness. Thank you so much. We will try to disturb you once again after giving sufficient notice. But
Thank you very much.